Okay, so we are going live now, and we are also live streaming on YouTube. We'll start with an introduction video, a short video, followed by a few tech announcements, and then we can start with the panel discussion.
Just wait like 2 seconds. We're just going on YouTube. Oh, I'll give a cue before we go on.
Event will start earlier. We are still 9 minutes away, right?
We have a few videos and a few tech announcements to make, so that will save us some time. And we already have people waiting in the attendee panel.
Okay.
So, yeah. Okay. So we are live on YouTube. I'm just going live. I mean, attendees will start joining now. Okay.
I invite Ashmita to announce the tech announcements that we have for today.
Hello, everyone. You can choose your preferred language by clicking the globe icon at the bottom of the toolbar on your device screen. Available languages are Bangla for Bangladesh, Khmer for Cambodia, India Tamil, Bahasa for Indonesia, Sri Lanka Tamil and Sinhala for Sri Lanka, and English. Please note, due to Zoom's limitations, we are using Korean channel for India Tamil, Japanese channel for Sri Lanka Tamil. Other languages are accessible on audio channels under their respective names. This event is being recorded. We have the chat box and Q&A box open for participants. Please type in your comments and questions during the event. We will take questions through Q&A box after each panel discussion. This event is being live streamed on Facebook and YouTube. Link is in the chat box. Please show us some support by live tweeting about this event using the hashtag #EndWageTheftNow. Thank you.
Ananya, we can start with the discussion today. Ananya, you're on mute.
Yeah. Welcome everybody to the second part of the two-part global series organized by Asia Floor Wage Alliance. Last week, on July 7th, we had a webinar which was attended by over 450 participants across 45 countries. And there we launched the report across 6 countries in Asia, documenting wage theft suffered by garment workers who manufacture for products for global brands. And the wage theft was caused by brands' irresponsible actions. So last time we reported on the massive amount of wage theft, indicating the fact that the responsibility lay with global brands. Today, we meet to explore solutions. We are today going to be discussing the strategy of joint employer liability, using national laws in production countries in Asia to hold brands legally accountable for their obligations. We tried throughout the pandemic time, starting from last year, demanding that brands contribute to the wage loss suffered by garment workers who were already being paid poverty level minimum wages and who were barely surviving. However, all the demands fell on deaf ears, and there has been no response from brands. There have been campaigns done by different organizations globally with very little to show for it. So today we are going to be discussing the strategy of joint employer liability. The program today consists of 2 panels over 2 hours. The first panel will consist of labor leaders and lawyers in Asia who have taken steps to use this strategy in their home countries. The second panel will consist of legal experts from Asia, Europe, and United States with many years of experience in corporate accountability, due diligence, labor laws, and the use of human rights instruments. These experts will discuss the value and implications of this strategy based on their own experiences and assessment. Before we go into the two panels, we will have a presentation from Ashim Roy, who will present Asia Floor Wage Alliance's Joint Employer Liability Strategy in a general way, conceptually. Ashim Roy is a senior trade union leader in India and also the former and founding General Secretary of the New Trade Union Initiative. He is a member of Asia Floor Wage Alliance's International Secretariat. After Ashim, we will begin our first panel and I will introduce the speakers at that point. Right now, I invite Ashim to please share the presentation. I request all speakers to be aware that we are having simultaneous translation conducted in 9 languages, not including English. So 9 language simultaneous translations are going on because we have people joining from across Asia, not to mention all other countries, but the translations are for Asian production countries. So we have 9 languages going on. I request all speakers to be aware of that and to speak a little slowly with some pauses. So Ashim, please go ahead with your presentation.
Yeah, thanks, Ananya. Can we have the slides coming in? Yeah. Thanks for calling me to make this presentation on behalf of the Asia Floor Wage. In the last discussion that we had come to the idea of wage theft. And essentially, we presented the wage theft as an illegal action on the part of the brands and the suppliers under the national law. It's an illegal deduction. And so we wanted to figure out and explore in this discussion today, and I will make the broad principles and frameworks on which we are thinking of how to take steps to hold the brands accountable for the wage theft in the national jurisdiction. Next. So the first point which I want to kind of elaborate on is the idea that this is a litigation strategy. It is a strategy to think through the possibility of taking action against brands. And the idea is that we would be taking brands against, filing cases against the brands in respective countries. But if you go back to the core idea why we are doing it, we also want to open up the idea that the brands are not buyers in the garment market. Essentially, the brands go away by, even in the normal language, we have turned them to buyers, which is true to a certain extent, but essentially they're not buyers of actually garments. They actually have manufacturing contracts and not purchase agreement. It's a well understood concept. The idea is to understand what this manufacturing contract means. And we want to link that manufacturing contract to the broad idea of what an employment contract exists in the supplier factories. And in that process, show the relationship between the employment contract, the manufacturing contract, and how the employment contract is based on the manufacturing contract. We will be actually wanting to show how this is linked together and they come within and our effort to bring within the national jurisdiction the Asian production countries. This is essentially coming out from the need that we have felt as a movement of looking at the governance gaps that exist in the supply chain, one, and that all our efforts at a global level has not been able to fill up this gap. And the second, that in the end of the day, workers and unions want agency in fighting out these issues in their own country. And so we want to see how brands can be brought into the country. Next slide, please. Looking at the employment relationship in the government supply chain, and we do want to kind of show that there is what is hidden from the public view is that there is actually a contracting for production. And it is in this production that the employment relationship is embedded. And so, because it is hidden from public view, we cannot actually see the legal accountability that can possibly exist in the production countries against the brands. Our attempt here is to show and see and evaluate whether such a possibility exists or not. There are three core points that I want to make here to show that there is an employment relationship in the government supply chain. One is that it is a well-established thing that is a long-term business relationship, which is symbiotic almost. One cannot exist without the other. And this is between the brands and the suppliers, what we call the first-tier suppliers who have actually a legal contract for production. And this is what is most important to understand, that this is not this economic relationship between the two are conceptualized in a contract called contract for manufacturing. So this actually, what does it really do? This offshoring by the brands for their production, even the garments that are produced in the supplier factories are labeled and cannot be sold by anyone else but the brands. So what does it really mean when you offshore the production, the necessary branded production, the production for the brands? In our view, that it risks the risk of the production, all the risks that exist in the production, including the risk of violating statutory liabilities, is something that is disinvested. So essentially, the brands have got away from, disinvested from the production processes and invested into the design, marketing, and retail, where they think the largest share of the profit exists. We would actually go in the next, as we go forward, we will go and see that how this contract for manufacturing shapes, conditions, and controls the employment contract between the suppliers and the workers. We will, by doing that, we will show that both the contracts are linked, and that is one of the assumptions on which we are building this litigation. Next. Now, this is not a new concept. Joint employer has evolved in various countries, somewhere in common law tradition, somewhere through law, legal conceptualization. But essentially, the whole point of joint employer liability has evolved in order to what is called in some countries lifting of the veil, to unmask and bring out the true employment relationship between the employer who says that the worker is not my employer, and the worker who's actually employed by someone who's actually an agent of the principal person. So placing responsibility on those who ultimately benefit from the business. So the core idea is to show who benefits from the employment. And if the worker is working, who gets the benefit of that output of the workers in the final reckoning. So we want to identify the principles by which this joint, or what is called the principal secondary employer relationship, or a principal secondary employer, subsidiary employer relationship into it. There are 4 or 5 tests. The one test which is very common and has evolved, including the very recent one, is the integration test, where one is trying to show that is there an organizational relationship between the worker who's claiming to be who's claiming a joint employer status, to the employer who says he is not an employer, but actually is integrated so well into the organizational framework that one can invoke the integration test. And courts have evolved very, very detailed methods of testing out the relationship. The second is, and this is a very old master-servant relationship, it has evolved in a much more bigger way now. From supervision, it has gone into the supervision and control itself has expanded in the last decades. In fact, the recent judgment of Uber case expands it to also where the principal employer is liable for statutory rights of workers hired by an independent contractor. So if there's statutory liability that he has contracted out, the Uber case is actually held. So the question is that we want to use the test of control as enunciated by various judgments over the world to put the point of view of the control. The third, and this is very important, there is a growing jurisprudence on the idea that if a brand is liable for something in his own home country, what is the manner and in what way can it be extended to the supplier's jurisdiction, where it is actually doing something, in this case, the production of the principal brand's garments. So can it be extended? This is a test that we have to say, and I think there are already judgments which has gone and expanded this idea.
Ashim, you have 2 more minutes.
Yeah, this slides you mean, right? Or 2 minutes for everything?
2 more minutes for your presentation.
Okay. Oh. So this is, so I'll cut this short. So we have economic reality test, we have the control test, and we have many other cases which can be elaborated to tell us how we can go forward in this way. Next slide, please. Yeah. The key questions that we have for testing whether national jurisdiction, whether these questions can be tested in national jurisdiction, is to really go about, again, using what is called the lifting the corporate veil between the commercial agreement between the brands and suppliers, and seeing the test that I have just stated or some other test that has evolved, and examine whether such a relationship exists. Essentially, it is to show there's a principal-agent relationship, and in our viewpoint, the brands or suppliers are actually integrated in a business way. There's a functional integration with interdependence, and in many ways, the suppliers are actually contributing to the core business of manufacturing for the brands. And that is what brings to one of the crucial tests, that what is the economic reality of relationship between the worker, the supplier, and the brand. And we know for sure that the workers have a total dependency on the brands for their employment and for their livelihood. Next slide, please. These are the standard elements by which manufacturing contracts establish a joint employer liability. I'm not going to do the whole report says this in a much more detailed fashion, but essentially the brand's power to control, which is I have said earlier, and we know that there is actually, if you go back to how the production is managed, we will be able to see in the manufacturing contracts how detailed specification, quality, number of threads, there are huge, large number of detailed specification which has to be monitored in the production floor. To the extent that brands can reject orders at any moment and can conduct audit at any moment of the production process, which gives it a tremendous amount of control over the production process. The second core part is whether the workers integrate to the business model of the brands. As I have shown, as I've talked earlier, and as we go forward, we will figure out that there's a directly linkage to the manufacturing, which is needed for the brands in order to do their business of marketing and retailing, and that is performed by the workers. And so the net result of that is the production capacity of the suppliers, including workers, are completely dedicated to the manufacturing of the garment of the brands. They're not manufacturing for themselves. They are dedicated to the manufacturing of the garment for the brands. This, for us, brings up the long-term relationship, which is between the work of the suppliers and the brands and the workers. The last element is the economic dependency, and we can again go in detail as to show that how the orders are, the orders also create the condition that the workers in the suppliers companies are economically dependent on the brand. And in fact, if the contract of manufacturing ceases to exist, the work employment will come to a ceasing. And so there's a relationship of economic dependency. Next slide. And this brings up to the one other broad area. We do think that there are certain principles of liabilities and legal concepts that are already there and evolved in various jurisprudence which we can draw in. And I don't want to go in detail, but there is a question of vicarious liability when actually one can show that the agent has done on behalf of the master. There is an idea, and this is very prominently in the brand, because brands go and claim all over the world through their code of conduct, through their advertisement, that they're doing fair employment, they're complying with all the labor laws and all the national laws in the countries where they're producing. So there's a promise that has been done, and we can show that the wage theft issue was something that they have violated, that code that they have promised before the workers and to the world. Similarly, we want to also show by underpricing things, by not paying overtime, but not paying terminal benefits, they're actually enriching in an unjust fashion. And that's what a very important criteria for deciding who is gaining from this relationship.
Yeah, I request you to wrap up, Ashim.
Next slide. Yeah, just want to link it up with the broad idea that has come in. There are two basic approaches that are coming up. I think both the approaches are very important. To the due diligence approach, which is which we call home country approach, where basically duty to care is being exercised and more legislative mechanisms are evolved to see that human rights violations are actually detected and they are also made accountable in manners in the home country. We still feel there's a gap of not being able to make it in the production countries, and that gap is something that actually undermines the possibility of making workers actually legally challenge the brands in their own home countries. And that is why we believe that legal accountability has to be brought in, and that is exactly why we think that joint liability legal strategy has to happen. And this is just the last slide, right?
Yes.
Yeah. So I would just conclude by saying that essentially we want to bring back the workers and their unions, the agency, to actually do a litigation and make the brands legally accountable, not in faraway home countries of the brands, but in their own production countries. So we can actually make the workers and the unions, the agency for making it legally accountable. Thank you very much.
Thank you, Ashim, for presenting very complicated things in a short time. Our speakers will be now discussing the experiences of trying these strategies in their countries. In the first panel, I would like to invite the first speaker, Karamat Ali. He's the Executive Director of Pakistan Institute for Labor Education and Research, PILER, in Pakistan. An eminent labor and development activist for the last 5 decades, Mr. Ali is the founding member of PILER, as well as various local and regional networks like Pakistan Peace Coalition, Pakistan India People's Forum for Peace and Democracy, and South Asia Labor Forum. He has been a part of labor and peace movements in Pakistan and has played a key role in linking up these movements with regional and global counterparts. Karamat Saab, please go ahead with your presentation. You are muted, Karamat. You're still muted. Yes, I think it's fine.
You should know we live in a country where everything is mostly muted. So anyway, but we manage to speak up sometimes. So, so I won't sort of repeat anything that Ashim has just said. I think if we look at the principle, whether there is enough legal sort of basis to assert that or not, the fact remains that the brands are actually the principal employers in my view, because I'll just point out the case of Ali Enterprise, the known as Baldia factory fire case from 2012, where one German brand, KIK, was sourcing almost over 90% of the production of Ali Enterprise. So basically, those workers were almost exclusively producing for KIK. And we had some sort of very rudimentary kind of recognition of the fact that they also had some responsibility towards the workers in the producing countries. That was mainly in the form of codes, codes of conduct of the brands themselves, and in some cases, the governments in those countries also had some codes for the brands based in their countries to follow when they go and buy or order things in our countries. And then the other thing that was often used by workers was the OECD sort of guidelines. And a number of cases are there where workers in the multinational corporations that were based in our countries, they took the violations of the OECD guidelines and got compensation for that. So, but it was not really a legal or established legal framework. I would like to bring to your notice the fact that now we are moving towards established legal frameworks, and already a law has been sort of passed in Germany about the liability of the brand German origin brands with reference to the rights of the workers in the production countries. And the law now allows that workers from and unions from the producing countries can go and file cases against the brands in their country of origin. So Germany has taken the lead, and it's a lot linked to this whole issue of the Ali Enterprise. And there were problems both at the national level and at the international level. So, for example, the employers were responsible for getting the workers registered with 3 different welfare organizations like Social Security Institution, Employees Old Age Benefits Institution, and Workers Welfare Institution. And from Ali Enterprise, not even sort of 1/3 of the employees were registered. And we took this case to the local court, and the court agreed with our prayer, which was that it is not the fault of the workers because there was no process of self-registration. It's the employer who had to get them registered. So it was not done. So the court ordered that they should get all the benefits from these 3 institutions like death grant, etc., etc. And that fact got established now in the Pakistani law. So people were able to access that. And then it's very interesting because of those courts and this German KIK, they contacted some of our friends in the Bangladesh Garment Workers Unions and asked them, look, we want to go to Pakistan and we want to help the workers. So can you give us some contacts? So those friends gave Pilar's contact to them, and they contacted us and that we want to come. So we said, okay, come. So they came to Karachi and we had a meeting, and they started with the statement that although we have no responsibility in this case, but we would like to help the survivors and their families. So we said, no, I mean, we are not a charity organization. We can put you in touch with ED Foundation. You can give this charity through them. But we don't agree with you that you have no responsibility, because we know that there is some code of conduct that you must have followed. You have not done it. You were supposed to ensure that the basic laws in Pakistan are implemented in the factory from where you are sourcing, and almost the entire production was being done for you. So they said no. So we said, okay. So we just walked out of the meeting, and then they came back the next day saying, well, we would like to discuss. So we went back. Then we had a long discussion about this whole responsibility thing. And they said, okay, we will go back and we have to talk to our board of governors, and then we will let you know if we can further talk to you or not. So this was in the early October. In December, they contacted with us saying, can you come to Germany? So I said, no, we won't come to Germany. You come to Holland, because we were coordinating with our organization friends, Clean Clothes Campaign. So said their head office is in Amsterdam. So you come to Holland, we will have a discussion there. So they came. And then they made a slight sort of movement from their earlier position. And they said, okay, what we want to do is we want to give some support, financial support as, immediate relief.
Karamat, you have 2 minutes left. It would be really helpful if you talk about the legal work that you did in Pakistan, because a lot of work was done around this.
So what I'm saying, they came up with the draft, and we signed an MOU, and under that MOU, they sent $1 million to be distributed amongst the. We did that through the High Court, so it has now become a legal, precedence also. The High Court set up a commission, and the commission distributed. It took about 6 months, and these people were very upset because they were under a lot of pressure from the trade unions, from the media, from organizations such as Clean Clothes Campaign, etc. And then they said, we are now not negotiating. So finally, in the legal sense, what we did was we took up the ILO Convention 121 regarding injury and death at the workplace as a result of accidents which had never been taken up. The net result was that finally they signed an agreement, and they recognized their long-term responsibility, and then they had to deposit $5.15 million for a long-term process of monthly pension, which is in place. And now this is part of the legal sort of system. Anywhere, recently there is a 52 people died in this factory fire in Bangladesh. I'm sure those friends can take it up and use the ILO's judgment on that and claim long-term compensation for the members. So
okay.
There are, and then I said earlier that Germany has already legislated for a whole responsibility throughout the supply chain and the liability to the local laws as well as to the international law by all the brands who go and source from developing country.
Yeah.
So we have that, and I think the European Union is going to take it up now. We had a meeting with the ambassador of European Union today, and she said, yes, in 2 years' time, all European Union members will adopt such laws in their countries. So
thank you. Yeah. Thank you, Karamat. And also, right now, a complaint has been filed in Pakistan on the wage theft that has been documented.
Right.
And of course, as Karamat said, the kick case has been one of the earlier cases and is a very helpful precedent to build on. Our next speaker is Iwan Kusmawan from Indonesia. Iwan was actually a worker in a shoes factory for 11 years. And from worker leader, he became a factory level union and has long since been a national leader of one of the largest unions in Indonesia. He was the national chairman of SPN till 2019. He continues in the national leadership of SPN and he heads its international relations department. A very visionary leader, always looking to stretch his imagination and explore new possibilities. I invite Iwan.
Ya, baik. Terima kasih Ananya. Terima kasih buat kawan-kawan yang telah mengorganisir acara ini. Selamat malam. Saya akan menyampaikan terkait dan persoalan mengejar tentang tanggung jawab brand. Saya mungkin bisa menceritakan pengalaman sebagai pekerja, juga sebagai pengurus serikat pekerja. Di masa Orde Baru tentunya, karena saya bekerja mulai 88 dan berakhir di tahun 98. Dan sampai dengan Orde Reformasi di tahun 98. Bersamaan dengan krisis ekonomi pada saat itu, di mana saya pada saat itu masih bekerja di pabrik sepatu dengan beberapa merek atau brand yang cukup ternama di tahun 88 sampai 98. Di antaranya adalah ada Reebok, ada Nike, ada Adidas, ada Puma, ada Ascot, ada AFWA, Champion, Spalding, dan Brooks. Itu adalah merek-merek yang di saat tahun-tahun 88 sampai 98 itu adalah merek-merek atau brand-brand yang memang berada di dalam pekerjaan saya di sebuah pabrik di saat saya masih bekerja. Namun demikian, karena terjadinya krisis ekonomi pada saat itu, maka pabrik di mana tempat saya bekerja itu adalah pada akhirnya harus tutup. Harus tutup sehingga saya harus berusaha semaksimal mungkin menuntut hak daripada para pekerja untuk mendapatkan pesangon. Dalam kondisi seperti itu memang agak sulit karena kita dihadapkan dengan sebuah persoalan resesi ekonomi dan lain sebagainya. Namun demikian kami tetap menuntut. Pertama adalah tuntutan kami kepada perusahaan di mana kami bekerja itu harus membayarkan hak-hak pesangonnya sebagaimana yang telah diatur di dalam undang-undang. Di sisi yang lain, kami juga menuntut kepada brand yang tadi saya sebutkan, brand-brand yang ada, dan saya sebagai ketua serikat pekerja di basis pada saat itu mencoba untuk mengirimkan surat kepada brand. Karena kebetulan kami pada saat itu didampingi oleh GLJ-ILRF. Itu bagian daripada mitra kami pada saat itu. Nah, kami juga memahami tentang Code of Conduct. Karena pada saat itu kami hanya belajar, kami hanya melihat dari Code of Conduct. Yang kami pahami, Code of Conduct itu adalah bagian daripada pedoman penuntun perilaku antara brand dengan perusahaan. Sehingga isi daripada Code of Conduct itu adalah mengatur tentang hal-hal yang bersifat normatif. Sehingga perusahaan ketika mendapatkan order itu, baik itu Nike, Adidas, dan lain sebagainya, di dalam Code of Conduct itu tidak boleh ada pelanggaran-pelanggaran. Nah, dasar daripada itulah sehingga kami bisa melakukan upaya-upaya untuk melakukan perjuangan tadi, menuntut hak-hak kami kepada perusahaan melalui hukum nasional dan menuntut kepada brand-brand melalui bantuan GLJ-ILRF. Itu yang kami lakukan. Nah, singkat cerita dari perjalanan perjuangan yang kami lakukan pada saat itu, kami alhamdulillah karena kebetulan ada hukum di nasional pada saat itu adalah namanya itu P4P, Panitia Penyelesaian Perselisihan Perburuan Tingkat Pusat. Dan itu kebetulan berada di kantor Kementerian Tenaga Kerja. Sehingga ketika ada persoalan-persoalan yang masuk di ranah P4P, maka menteri bisa hak veto gitu. Nah, kekuatannya ada pada hak veto menteri. Nah, dari perjalanan kasus tersebut, maka masuk pada satu titik putusan bahwa kami diberikan kompensasi itu di atas daripada norma yang diatur di dalam Undang-Undang Hukum Nasional Indonesia pada saat itu. Jadi kalau boleh kami katakan, kami lihat pada saat itu, 2 kali ketentuan hukum nasionalnya itu adalah yang memang menjadi normatif, dan 1 kali ketentuannya itu adalah yang kami rasakan itu adalah antara kerjasama antara buyer dengan brand dengan perusahaan. Sehingga kami mendapatkan 3 kali ketentuan pada saat tahun 1998. Jadi memang kalau dilihat seperti itu, ini cukup panjang, ini cukup alot dan lain sebagainya. Namun demikian, karena kami mencoba untuk terus berjuang, sehingga di saat-saat seperti itu adalah saat di mana terjadinya perubahan politik di negara kami, sehingga apapun yang kami lakukan adalah alhamdulillah menghasilkan nilai yang cukup baik. Nah, di sisi yang lain, masuk di posisi sekarang,
Iwan, if you can, you have a minute or 2 left. That's we have to wrap up. Yeah.
Oke, di sisi yang lain terkait dengan pengalaman saat ini di masa Orde Reformasi terkait dengan persoalan mengejar tanggung jawab brand, dan kebetulan kalau bicara tentang penegakan supremasi hukum ketenagakerjaan di Indonesia saat ini sangat dipengaruhi dengan persoalan politik nasional. Oleh karena itu, kalau kita dalam rangka mengejar brand dan hanya mengandalkan hukum nasional saja, ini sangat sulit. Nah, oleh karena itu, kami berharap bahwa ketika ada persoalan-persoalan dengan brand yang menyangkut pelanggaran norma-norma kerja seperti misalnya kebebasan berserikat, terkait dengan pencurian upah yang sedang kita bicarakan, ya, dan lain-lain, maka tidak bisa itu hanya diandalkan oleh hukum nasional. Tetapi ini harus dilakukan secara bersama-sama, mengejar tanggung jawab brand melalui Joint Employer Liability ini. Sehingga ini sangat memungkinkan, karena bagaimanapun juga ini sangat dahsyat kalau ini bisa dilakukan oleh semua serikat pekerja melalui hubungan internasional untuk mengejar tanggung jawab daripada brand ketika ada perusahaan-perusahaan yang melakukan pencurian upah seperti yang terjadi di saat pandemi saat ini. Jadi itu yang perlu saya tegaskan sekali lagi, maka ini sangat penting, kita perlu berkolaborasi secara internasional dan kita perlu mengejar brand yang dimana brand itu memberikan pekerjaan kepada perusahaan-perusahaan yang ada di manapun termasuk di Indonesia. Saya pikir itu poin penting dari saya. Yang sangat penting sekali lagi adalah bahwa jangan lupa bahwa Code of Conduct itu harus dipahami secara mendalam. Karena kata kuncinya ada di dalam Code of Conduct, itu yang pertama. Yang kedua, kita tetap harus mengejar brand-brand yang memberikan pekerjaan kepada perusahaan-perusahaan, di mana perusahaannya melakukan pencurian upah kepada para pekerjanya. Apalagi di masa pandemi COVID-19 di saat ini, karena ini dijadikan raw model untuk melakukan tindakan-tindakan pencurian upah. Bukan hanya upah sebetulnya, tetapi juga termasuk lembur dan lain-lainnya. Saya pikir itu yang perlu saya sampaikan dalam kesempatan.
Thank you. Thank you very much, Iwan.
Okay. Yeah.
I am sorry to rush people. We have a long program. Our next speaker is actually the lawyer who has been working on wage theft with all the unions, Gerry Michael Purba. He is a lawyer and the legal analyst for Asia Floor Wage Alliance. Yep. He is also a lecturer and researcher. Gerry will be giving the way we have been analyzing the Indonesian law to support joint employer liability, which the Indonesian unions are right now trying out. Yeah, Gerry,
Okay.
go ahead.
Okay, thank you, Ananya. So I will just go to the point because our time is short.
Speak a little slowly. Speak a little slowly.
Oh yeah, forget about it. Yeah, okay. So in a nutshell, yeah, we will reason that the relationship between brand and government is not just a trading partner, but a like employment relationship, because there is a control over its supply chain. After that, we will use the vicarious liability, you know, the master and the servant thing that Ashim has explained before. But we find a problem in here. The problem is like this: brand may argue that they buy from its supply chain, and they and the supply chain are separated legal entity. Hence, they reason that brand is not responsible for the violation of the rights in its supply chain. So that's the problem. How do we solve this problem? Actually, Indonesian Civil Code, Indonesian Civil Code is ex-Dutch Civil Code, has already acknowledged this problem hundreds of years ago. So in Article 1601 in Indonesian Civil Code, the law categorized the contract of doing tasks or of doing jobs into three categories. The first one is contract of services, contract of services, contract of employment, and the third one is contract of wholesale, or in Bahasa we say it pemborongan. Contract of wholesale is contract to do a certain task. So contract of services in the law is contract which regulates by the written law, where the other party do the service temporarily and another party does the job independently, such as lawyer, doctor, and etc. And the contract of employment is the contract between the master and the employee for a certain time. There must be a subordination relationship in here, or in Dutch, they call it dienstverhouding. So there must be a master and subordination relationship. In the contract of wholesaling, another party does the given task, and when it's done, the other party receives the compensation. Hence, as we know that the contract of services is regulated by the law, and there are only two options now. It's contract of employment or contract of wholesaling. What is the difference between contract of employment and with the contract of wholesaling? So let me give you an example. There is a case, let's say Van Hemel makes a contract with Spinoza. They agree that Van Hemel will give Spinoza 3,000 euro if Spinoza can make him a typewriter. And in that agreement, they also agreed that every month Spinoza make a new typewriter, and Van Hemel will give him 3,000 euro when the typewriter is done. Van Hemel also dictates Spinoza on how he must make the typewriter. So what kind of contract is this? Is it contract of employment or contract of wholesaling? Van Hemel may say, oh, this is contract of wholesaling. Spinoza say, this is contract of employment because he wants employment benefit indeed. So in Indonesian Civil Code, ex-Dutch civil law says like this: if there are signs in the contract that contain clause that can only be found in the employment contract, then it must be considered as an employment contract. So in that case, in the case of between Van Hemel and Spinoza, it's not contract based on a trading, neither contract of wholesaling. So it must be a contract of employment because there is a subordination in there. Yeah. So in other words, control stipulates a subordination. Control stipulates a subordination. If the contract in the contract contains a control, then it must be a contract of employment. But what about in our case? This relationship is mostly made between a corporation and another corporation. How do we solve this thing? I mean, that case between a human and a human. What about the case between a corporation? So a corporation in the law is considered as a artificial human. In the Dutch law, there is a real human, naturlis persoon, and there is an artificial human or rechtspersoon, such as corporation. Both sides have the same legal rights and responsibility. So the evolution from a bunch of individual person to create an artificial human as legal entity does not mean that the artificial human does not hold the same responsibility with a bunch of individual persons. Because if it does, then a corporation can be used to avoid some legal responsibility that will make the goal of the law fails. So hence, this is the point. Hence,
yeah, we have to wrap up, Gerry.
Yeah, the transformation from a bunch of individual persons to a corporation or the status of legal entity does not mean that the corporation can escape from the responsibility that a normal or entrepreneur holds. So that transformation does not eliminate that responsibility. I mean, Ashim already explained about Uber case. That's interesting because when we are trying to make this case, the judge in the Supreme Court in the UK hold the same point of view. So this is really interesting, and hence the same responsibility can be used. The relationship between the government and brand is not trading partner. It is based on the employment contract. Why? This is the reason. Brand has a control on how to make a product. And it also have a control over, they make an audit also. So they also controlling in the form of auditing. And the third one, this is really important. They have IP rights in the form of copyrights and trademark. IP right is privileged right and has a monopoly power. This right is excluded also in the competition law. So IP right stipulates a control because they cannot create these stuffs without the license or without the control over the brands as the owner of the IP rights.
Yep.
And from there, we can use that curious liability. I think that's all from me. Thank you.
Thanks a lot, Gerry. Sorry to rush.
Yeah, no problem.
Our next speaker is Athit Kong. Athit is from Cambodia. He is the president of CCAWDU. He is a former garment worker who was terminated due to union activities in 2001. And since then, he has become a national and an international trade union leader in this sector. CCAWDU is one of the strongest and most militant unions in Cambodia. It provides a strong voice, and it was the lead union in organizing massive protests that helped Cambodian garment workers win significant gains in minimum wages some years ago. So he's a very strong leader, and Athit joins us today to give his thoughts on joint employer liability. Athit?
Yes. Thank you, Analia. And
Athit, is your video working?
Yes. So shall I?
Please turn
so
it
it's
on.
a bit late. So
oh, okay.
Yes.
I mean, it's good for the audience to see you. Yeah, go ahead.
Yes, I am at home, so sorry if anything that. So okay, thank you. So let me see a bit my slide. Yeah, so thank you, Ananya. So good to see you all, and great to hear from the first speakers about this solution for the worker. So yeah, I think I got a few points that has the, why it's hard to, bring the employer to join the, bring the brand to join the employer liability. So I think from my experience, I think at the moment, brand is still the strongest in the system, so they have the indirect or direct, support from the weakness of the government and employers. And we have a lot of issue that in common with that we found that in common with employer, but the employer is still, taking advantage also from the system, even they know that the brand is benefit more from the system, but they are in the comfort zone, say they don't want to move, and our union is still weak. So this is the the thing, and the employer also, the brand also trying to play as a victim. So even in the COVID-19 crisis, the brand also, you know, try to be even more becoming a victim, that they are not benefit. So they also the victim from the system. So they are not part of these things. So, you know, all these things that, but in fact, they are still the strongest system, you know, in the system. And the other point is, I mean, we can try to blame the other, but in the union we still have a lot of disagreements, you know, between the north and the south. You know, I am like Ananya has said that I am growing from a garment worker myself, and then becoming the national union leaders and becoming a part of international union leaders. So I learned quite some experience that not only because of the other strong, or, you know, the strength of the other, but it's also the weakness of our movement. So the disagreement among the union movement, and also, you know, some strong union in the north, you know, they have different way of doing things. I mean, so at the moment the brand still taking this advantage, you know, by using the social dialogue, you know, kind of ideology and things like that work in the Europe and work in some of the advanced Asian country, but not in some of the you know, Southeast Asian and some of the weak region. So I think the unity, it's still faced with some barrier between the strong and, you know, and weak union, and between the south and north. So you know, it seems like the union that in the strong country, like you know, in Europe, or some in US, and they still has their own how to say it, territory, or their own zone to protect. So the barriers that need to build the global unity is not really breakthrough yet at the moment. So I just had a meeting with industrial meeting yesterday, so which is the same time. So we still have a lot of debate inside how to go forward with this wage loss, with future social protection for workers. You know, we still have a lot of debate, and how to find and maybe how to go back to the unity, and the way that union function. I think it's very basic that in Cambodia, in any other country as well, like we can have a strong organize, and we have the legal, you know, foundation, and then we can go on strike. I mean, we can go on campaign. So we can stay in the social dialogue, or in the, you know, communication, good relation, as long as the party need respect, and worker can craft the benefit and improve the working condition, and our union still grow. But if we lose all those things, I mean, we need to go back to our own superpower, like what I call, we should never lost our own superpower. Whatever we into any agreement, we are into any dialogue, but we should not let out or get away or lost our superpower. So I don't know, maybe our superpower is the maybe general strike or campaign or put pressure on the brand or legal issue, but we need to obtain our superpower. So And the other issue that I want to also mention is the you know, the strong, we have a problem a bit, like union criticize NGO and NGO criticize union. So still now that you know, I think we need to build the same objective. We whatever it is, I mean, if we have a united and strong objective, so then, you know, the unity should be there. I think the big and strong NGO and big and strong union need to find, I mean, whether in the north or in the south. So we need to find the leadership of both organizing way, need to find a way to unite. So in my experience, this is also the advantage of the brand and employer to get away from their responsibility if we are not united, not inside the union only, also between the union and NGO. Yeah, I go back. I also go to, yeah, we now, according to my experience, we lost our superpower to employer and government. You know, we lost even more during the COVID-19, you know, crisis. So now the worker in Cambodia and the brand, maybe the worker in Bangladesh and other, now the brand do everything they want, and the union still discuss, and you know, we still fighting between, we still debate. I mean, I would not call it fighting, but we still debate. So I think this is quite sad, right? So if we have the power in the union, and also we get also support from the NGO or the social movement or community movement, we must be stronger. We must not fighting against each other. So we can criticize in the way of, you know, how to say it, positive, or try to create something that lead us to be more stronger. So we believe, and everybody believe, that the only best way is to unite and to be you know, in one voice. It doesn't matter where we are from or where we are in different form of movement, but you know, we all agree that we need to be united.
Yeah.
Okay.
Any final thoughts? Yeah, final thoughts, Athit? Are you?
Yeah. So from my experience, from the CCAWDU experience, so I think let out the thing that we still debate, but the best thing is, in our organizing way, we need to be clear on our organizing. We need to get MOS, we need to sign many CBA, you know, we need to build a strong national and international alliance, and you know, we need to try our best to utilize the power from different movements, you know. So all these things that we need to continue forward for our success. So, but the strongest is we have to be success in our organizing, in our union. Yes, thank you.
Thank you, Athit. So Athit has pointed out the challenges of holding brands accountable in an environment where brands have the maximum power and labor is still struggling in different ways to hold brands accountable. In the legal brief that has been published, there is a section you can read on the interpretation and analysis of the Cambodian laws for exploring joint employer liability. Different countries have different exploratory and analytical potential, and this is explained in the brief. However, from Athit, we understand the challenges so far that the movement faces. The question is, how do we move forward? And this is what is one of the topics today. Our next speaker is Swasthika Arulingam. She's a lawyer with a specific interest in labor law. She's from Sri Lanka. She has been working closely with Asia Florwage Alliance on developing the joint employer liability concept. She is also the Deputy General Secretary of the Commercial and Industrial Workers Union. And for the past 10 years, she has worked closely with workers in the garment sector, manufacturing for international brands in the free trade zones of Sri Lanka. Swasthika, over to you.
Thanks, Ananya.
You are also a fast speaker, so speak slowly.
Okay. I want to start my presentation by saying something obvious in labor law, which is that there is a golden thread which runs through labor law regimes in general, but also labor law regime in Sri Lanka. And this golden thread is the recognition in labor laws that any industrial relations free of regulations would place the employer and the employee on an unequal footing, whereby the employee would be powerless to bargain the conditions of employment. This recognition in labor law ensures that the law functions to balance off this imbalance and make the playing field equal for the employee to bargain fair working conditions and wages with the employer. In Sri Lanka and in many other parts of the world, this recognition resulted in statutes, case laws, giving an expansive definition for who an employee is under the law. As early as 1973, the superior courts of Sri Lanka have held that if a person employs another person through his agent without disclosing the identity of the actual employer, and eventually the employee discovers the true employer, then the employee can hold the true employer liable for labor violations. The Sri Lankan courts have further held that if a person or a company employs a person on behalf of another person, but projects to the employee that he is the employer, then he too can be held liable as the employer. And there are several judgments by the Sri Lankan courts since 1973 upholding this expansive definition of who an employer is as defined under the laws of Sri Lanka, including the Industrial Disputes Act. Now, the joint liability complaints which we have filed in Sri Lanka follows these principles laid down by Sri Lankan statutes and case law in identifying and exposing the brand as a hidden employer in the supply chain manufacturing process. The joint liability complaints makes the hidden employer, the brand, liable in addition to the supplier for labor law violations which take place in the course of employment. Therefore, our position is that both the factory and the brand have to be held jointly and individually liable under the labor laws of Sri Lanka for any production which take place on behalf of the brand. Our position in the garment factory that the garment factory cannot come to exist as an employer unless they have a contract with a brand to manufacture. In fact, this is the exact reason which was told to thousands of workers who were terminated during the pandemic, that we need to terminate you, we need to bring your work to an end because the brands have cancelled the orders. This was the reason given to thousands of workers who were terminated during the pandemic. Therefore, the joint liability complaint holds the brands together with the supplier liable and responsible for non-payment of proper wages, loss of jobs without notice, and extracting labor without proper compensation and social security contribution to the worker. We are no doubt aware of the unequal power relations between the brand and the supplier, but we are even more conscious of the fact that brands through their suppliers have consistently used threats such as cancelling orders, moving to a different country for production as a means of securing lucrative bargains where the brands can produce at cheap cost. And cheap cost of production always has consequences, and these consequences are ultimately always borne by the worker in the form of poor wages, unfair labor practices, unfair termination, excessive targets and overtime hours, and the suppression of workers from unionizing. Brands to date have avoided public scrutiny and accountability from labor violation by publishing documents which have words such as ethical sourcing, long-term relationship with suppliers, and regular brand audits. Despite the fact that these documents have only served to improve the brand image of being ethical, we in Sri Lanka will be holding the brands accountable for the positions they take in public and particularly with regards to workers. Our first complaint, which has been submitted to the Labour Department, has been accepted, and the Labour Commissioner has written to the Assistant Labour Commissioner asking for a report on this complaint, which we have submitted. And we, as trade unions in Sri Lanka, believe that this is a very important first step taken by the Labour Department in holding the brands liable for labour law violations in Sri Lanka. Thanks, Ananya. That's all my presentation.
Thank you so much. All the speakers on this panel have talked about the challenges in their different countries as trade union leaders, and also reflected on the past attempts and have reported on new approaches that are being taken. In the legal brief that has been published, you will find analysis on India, Sri Lanka, Indonesia, Pakistan, and Cambodia. And in most of these countries, complaints have been filed. Bangladesh is also with us, though they are not, we don't have a speaker today. And in Bangladesh, similar exploration is going on. I believe that there has been quite a few questions and comments which have been answered and fielded. We are really happy to get your interactions. I will now move to the next panel, and I will hand over to the moderator of the next panel, which is international legal experts reflecting on what they have heard today, and they have also read the legal brief, and it is their independent thoughts that they will put in front of you based on their experiences. The moderator of this panel is Jennifer Rosenbaum. She is the Executive Director of Global Labor Justice International Labor Rights Forum, GLJ-ILRF. She is an attorney and a human rights strategist. For over 2 decades, JJ has used legal, policy, and advocacy strategies to win access to rights and collective power for low-wage workers. She has advised worker centers on transnational grassroots collaboration. She's the co-chair of the American Bar Association's International Labor and Employment Committee and lectures on labor migration and comparative social justice lawyering approach at Harvard Law School. JJ, I request you to begin your panel. We are running a few minutes late, but that's okay. We are doing much better than we were doing last week. So I am quite optimistic, and I think we will have a great discussion. JJ, please go ahead.
Thank you, Ananya, and thank you to the entire Asia Floor Wage team for bringing together this convening, and in reality, launching a conversation that will begin here and hopefully carry forward with many of you in different ways. And thank you especially to our previous panelists for their analysis of how the pandemic exposed further what we know about the extractive nature of supply chains and challenging us as lawyers to focus on this question of using joint employer liability in the national context of production countries in Asia to hold brands legally accountable for their obligations, particularly for minimum wage and overtime, these fundamental rights. And I feel very called home by this conversation. The first work I did when I was called to the bar in the United States was represent farm workers in litigation on joint employer on wages and overtime. And so this fundamental issues of law is very important to me. And it's very important that we bring the old conversations into the new economy. And that is what I hear the challenge to be for all of us. In some ways, this is an old conversation, and we are standing on the shoulders of many garment workers and unions. Since garment manufacturing became an industry, garment workers and their unions have developed an analysis and fought for supply chain accountability, both in the courts through litigation and in the streets through strikes and other collective action. In the United States, this work was led by the International Ladies Garment Workers Union, and many of the precedents, the legal precedents that workers today rely on in terms of joint liability were won by garment workers doing exactly what is happening here, exposing the way that the industry was attempting to avoid liability and demanding liability and corporate accountability for these basic rights, minimum wage and overtime, and making the same kind of arguments that are being made here. And in some of these cases, the US Supreme Court talked about the evil of overwork and underpay and the need of all workers for a fair day's pay for a fair day's work. So in this case, the demand for joint employer liability is old, but it's also new in really important ways that the research Asia Floor Wage has done across so many countries is showing us. And in the way that they're calling us as lawyers to update the analysis of these legal factors around economic reality, economic control, economic dependency to meet the global economy, and that we can't leave this analysis in a 1930s economy. We have to bring it up to the way that garment manufacturing is happening today, and that it's our job as labor lawyers and movement lawyers more broadly to update this analysis and argumentation. And we know that garment brands have a business model both built on attempts to avoid joint liability through subcontracting of different sorts, and that sometimes they are successful in business and legal jujitsu around the cases as they're interpreted. But we also know that supply chain models are premised on control of production, control of logistics, control of timing, that the fast fashion has as many as 52 micro seasons. And so, we want to challenge ourselves to look at the actual notions of who controls contracting and whether suppliers can actually negotiate, who controls the money in the contract and whether there is enough to pay the wages of workers, and who controls the specifications and timelines of production. So our panelists are going to give us their insights into some of these questions. And again, as Ashim said in the beginning, what is the appropriate commercial description of the economic realities in this global economy, both relating back to what is historic and also what is new. along with what legal jurisdiction enables workers and their unions to have agency in litigation, which is another fundamental mandate that Asia Floor Wage has given us. We have an esteemed panel of legal experts today, and I will introduce each panelist and give them, we will have 5 minutes for discussion, and I will attempt to keep us on time so that we can have time for some questions and comments. I see a number of legal experts and unionists and ILO friends and friends from the movement here, so we do want to have time for a dialogue. Please do go ahead and put questions in the Q&A button if you have them as we go along, and we'll attempt to come back to them. It's again an honor to introduce these panelists and to be here with you all. Our first panelist is Jeff Vogt, who is the Rule of Law Director for the Solidarity Center, the largest US-based international workers' rights organization. He is also co-founder of the International Lawyers Assisting Workers Network, which has already a membership of 650 workers' rights lawyers from around the globe. So if there are some lawyers on here who like this kind of conversation, I'd encourage you to check out ILA and find some other friends there. From 2011 to 2016, he was also the legal director of the International Trade Union Confederation, where he coordinated legal advocacy before the ILO and other institutions and advised trade unions on labor law and policy. And also, for those of you who've been following the fight by employers in the ILO to diminish the right to strike under international law, Jeff actually wrote the book on how to defend the right to strike under international law. So Jeff, we really appreciate you being here, and I'll pass the floor to you.
Great. Thank you so much, JJ, for the introduction, and thank you to the Asia Floor Wage for inviting me to be a part of this launch of the legal report, and for the really excellent report last week on Money Heist. I think these are raising some very fundamental issues around global supply chains and human rights. So, congratulations to Asia Floor Wage for both reports. I think they are a very significant contribution. I only have 5 minutes, so I'm going to only touch on a few points here, and we'll try not to repeat too much of what's been said already, and speak slowly enough. I think, as has already been laid out, the non-payment of wages, if in particular, as we're looking at non-payment of wages during the pandemic, so over the last year and a half, has been a very, very acute issue, very serious problem. And not that this didn't exist, obviously, before the advent of the pandemic. It was already a serious issue, and now it's really a crisis. I with colleagues last year published a report that looked at the abuse of brand power over their suppliers by arguing falsely that they could invoke their force majeure cancellation clauses in their contracts with their suppliers, when it was pretty clear from a review of the law in a number of jurisdictions that if anyone had a claim of force majeure, it was the suppliers, right? The buyers, all they have to do is pay for the orders that they've contracted for, right? So, and as a result of the cancellation of contracts for goods, some of which were already on ships heading to the destination countries, there was a serious legal issue and a serious human rights issue, of course. And that's what, again, I think this paper is very important, laying it out. This asymmetry of power between brands and suppliers, either through the various purchasing practices that have been discussed, the short turnaround, the every year trying to get the same or more for less, so putting a very squeeze on margins with suppliers, and these very one-sided contracts of adhesion where suppliers are basically told, okay, here, if you want to do business with us, here it is, and if you don't like it, too bad. And if you complain about it, I mean, it's very easily, you can imagine that suppliers could be frozen out or of opportunities to supply goods, and not only to that brand, but all brands, right? So, so with the combination of the practical control they have through their purchasing practices and the controls that they have through the contract, it makes very clear, how brands are really responsible for setting what the scope of what suppliers are able to do with regard to their employment practices. And that is, while not at any means trying to let the suppliers off the hook for what they're doing, it is very clear that the reason why there's so much anti-union hostility, forced overtime, violence, harassment on the workplace are due to a number of the constraints that the buyers are putting on the suppliers from the beginning. The problem, of course, has been, and is a problem that is no accident. It's quite intentional. Is that in many countries, the domestic legal systems are extraordinarily overburdened. Cases can take a very long time. There are disingenuous appeals. So cases can last a very long time to try to get a remedy at in the local jurisdiction, while at the same time bringing cases against brands for their contribution or cause or contribution to human rights violations is extraordinarily difficult. There have been cases lodged against the German retailer Kick in Germany, which is unsuccessful. There have been a number of efforts, with the exception of the UK courts actually being quite generous to these kinds of claims. Finding justice at the home country's courts of the brand has also been difficult. I mean, the due diligence framework under the UNGPs, I think, does help provide some useful guidance, but they are in fact guidance, and I think unfortunately many brands have respected those guidelines in the breach, and it is only in 2 countries now, France and very recently Germany, that we see an effort, we see actual legislation that tries to bring those principles into hard law, and unfortunately the German law has no civil action. So 30 seconds left, I'll just say. Yep. So I think, again, just to commend this report, I think, thinking strategically about how we bring the justice back down to, as it's been said, a bottom-up approach, where we challenge the brands, where the manufacturing is taking place, and see if we can not use these theories around joint employers and other ideas that were in the paper could bring brands within the ambit of domestic courts and hold them responsible for the wages that are not being paid on a massive scale. Thanks.
Thanks, Jeff. We now pass the baton to Krishnendu Mukherjee. Krishnendu is an English barrister and an Indian advocate based at Doughty Street Chambers in London, where he's also the joint chair of the Business and Human Rights Group. He specializes in immigration, environmental justice, and business and human rights. And we see the importance of the intersection of those issues in the remarks on the first panel. He has lived and worked in India since 2007 on issues of corporate accountability, especially in relationship to claims for compensation and remediation on supply chains. And that includes the issues of asbestos-related diseases, silicosis in the stone industry, the garment supply chains and other supply chains. And he's recently started a project with other partners in relationship to the effects of global warming in the Indian Sundarbans. So Krishnendu, we're really appreciative of your time today and looking forward to your insights.
Well, good afternoon, everyone from London, and many thanks to Asia Floor Wage Alliance on the invite, and many congratulations for this initiative. In my short presentation today, I really want to highlight two things in relation to the joint liability initiative that's currently taking place in Asia, in relation to how it stops there being a safe haven, and secondly, how it can help to form the standards on which companies, parent companies, have to do human rights diligence in their garment supply chain. And I want to illustrate that through an example. During the lockdown in the pandemic in the United Kingdom, there was a spike in cases in the city of Leicester in England, which was traced back to the garment factories. Leicester has been traditionally a center of garment manufacture. And it was found that workers were in breach of the laws, working in those factories, sometimes sleeping in those factories to avoid detection. And that highlighted the evidence that really has been traced back for the last 10 years, ever since really the national minimum wage was brought into the UK in 1998, so a number of decades, highlighting the fact that minimum wages were not paid very significantly in these factories, and there was very bad health and safety, that there was breach of working hours and other labor law violations. And this resulted in one of the major buyers, a company called Boohoo PLC, who has made quite considerable profits during the pandemic because of its focus on fast fashion, having its brand image tarnished, and thereby trying to take steps to remedy their brand image and remedy their violations in their supply chain through an independent review that a leading barrister did, and through now currently mechanisms for both in-house auditing and third-party auditing. And I do commend people to look at the independent review that was done late last year, because it does provide a significant criticism of Boohoo, but also the lack of statutory protection for workers, but also provides some very good recommendations in relation to how companies can better monitor and remedy violations in their supply chain. But although Boohoo has undertaken this review and this auditing, there have been threats, for instance, in evidence to a parliamentary committee of moving its production to the very countries which are represented here, Bangladesh and Sri Lanka and Cambodia and so on, in order to avoid bad publicity and enforcement in the global north, in the United Kingdom. And I think that given that you have a situation where a brand can fairly easily move production to another country in order to avoid bad publicity or to avoid enforcement action, to a country where it hopes that the supply chains are more transparent, where there's corruption, where enforcement is less, and its brand image can thereby not be tarnished, indicates the importance of the joint liability regime, because there really should be no safe haven for abusive and exploitative practices which are conducted by garment brands in this way. And it's only really when the standards of protection are equalized in all of these countries can that properly happen. We've heard a bit today about the new human rights and environmental due diligence laws that are currently going from soft law into hard law regimes, most significantly, I think, with the proposal for an EU directive on a mandatory human rights and environmental due diligence law, which would have set standards for that in all of the EU countries. And it's clear that even here in the UK, which obviously isn't an EU country, in order to have a trading comparity, we would have to have something similar as well. But the joint liability regime can help set standards of human rights and environmental due diligence in the garment supply chain. There is absolutely no reason, in my mind, in my opinion, that the process which is currently being undertaken by Boohoo here in the UK in relation to its Leicester garment factories, in terms of identifying suppliers and having a list of suppliers, having a list of criteria which those suppliers are meant to abide by, couldn't apply to its suppliers in its first tier or indeed in its second tier or beyond in any of the countries which are represented here. So I commend this initiative, and I wish it all a success and for my involvement. So thank you very much.
Thank you so much, Krishnendu. This is so difficult. We would like to talk so much more to everyone. So I hope this is the preview for a much longer movie we will all get to be a part of going forward. It's now my honor to introduce Justice Rasheed Rizvi from Pakistan. Retired Justice Rizvi is a senior advocate with the Supreme Court and a member of the Pakistan Bar Council. He was elected as president of the Supreme Court Bar Association in 2016, and he is a life member of the Commonwealth Judges and Magistrate Association in the UK. He has also remained the president of the Pakistan chapter of SARC Law for more than 8 years, and has a long history of struggle for the rights of downtrodden people. He has a history of leadership on issues of labor and democracy, and in fact was a key leader in the movement for the restoration of democracy and the independence of the judiciary during the era of General Musharraf, including being a prisoner of conscience during that time as recognized by Amnesty International. So Justice, Your Honor, we're very appreciative of your time today and your insights, both as a member of the bar and a judge and a social movement leader.
Thank you, JJ. Thank you. In Pakistan, previously under the constitution, labor affairs were dealt with by the federal government. But in 2010, there was 18th amendment in the constitution, and Schedule 4 of the constitution was amended, and the labor business was transferred from federal government to the provincial government. Now the labor matters are dealt with by the provincial governments. We have 4 provinces in Pakistan and 1 capital territory, which is Islamabad. We are in Sindh province, and it has the biggest city of Pakistan, Karachi, biggest industrial area, and major labor force are found in Karachi. And even the migrants from all over the provinces, labor migrants are here in Sindh. Regarding COVID-19, there was an act enacted by the Provincial Assembly of Sindh on 5th June 2020, titled as Sindh COVID-19 Emergency Relief Act, regarding the employees and establishment was defined as any office, firm, factory, society, undertaking, industries, blah, blah, blah. And according to section 3, 2B, a restriction was imposed on all employers No employer or worker shall be no employee or worker shall be laid off, terminated or removed, and the employee shall be paid salary by the employer during the closure of an establishment as indicated in the Schedule 1. And at the same time, it also provided the government, means provincial government, may provide exemption in the provincial taxes, duties, fees, cess, levies, and charges in a manner as notified by the government. I have seen a very difficulty in implementing this law to seek the protection of this law regarding some employees. Because during the COVID period, majority of time the courts remained closed. Only urgent works were being taken and not this labor matters and labor grievance petitions in NIRC, which is National Industrial Relations Tribunal. They were only taking up emergency and they were avoiding to take up such matters. So although this was a very good law, but practically, I think it was hardly 20–30% implemented. Very, very hardly. As some of the participants earlier have pointed out, that the brands, in fact, practically, they are principal employers. And what we have seen in our case, when we say regarding Baldia fire factory case, where Ali Associates was involved, and as Karamat Ali has pointed out, we were successful to the extent involving Sindh High Court for distribution of the compensation received from German importer. Now, if we look at the working force in Pakistan, I can say with confidence that if in a one unit we have 100 workers, out of them, I think more than 60% are employed through contract basis or outsourced agencies. They are not the permanent employees of the manufacturer. And in case of any emergency, in case of any fire or other thing, even in garment factories, they don't have any insurance, any protection of law, because the law is not, labor laws are not applicable on contract employees. That is the very hardship. And we have filed a petition in Sindh High Court challenging the employment through contract basis. But again, for last 3 years, no hearing has taken place regarding that. So it will be very difficult in Pakistan to bring international brand into the definition of employer, because the employer as defined will only confine to the manufacturers of the unit of that mill, of that factory, of that industry. And we have to compel the provincial governments to amend the Industrial Relations Act 2012, and in order to bring the foreign brand also within the definition of employer. And for that, we have to contact labor trade unions to activate them to participate with enter in dialogues with the political parties. Otherwise, I think we can also file invoke jurisdiction under Article 199 of the Constitution, seeking a public interest litigation. But like our governments and administration and management. Courts are also very pro-employer and pro-management. So we have decided earlier that we are going to file a petition of public interest litigation, making all these grievances, raising all these issues before the Sindh High Court, and making and involving majority of civil society, labor, trade unions, politicians in this matter, just to highlight this issue and highlight this problems facing with the manufacturing industries involved with the foreign branded.
Thank you, Justice Rizvi. This is you've laid out some of the important challenges and also a very interesting strategy. So we will all want to be supportive and follow and learn from how you all are seeing it in Pakistan. So thank you very much. Our final speaker today from Cambodia is Mr. Sophorn Sek, who is a human rights lawyer based in Phnom Penh and is also the founder of the Rights and Business Law Office. He has also coordinated multiple national projects for the ILO, including those around indigenous land rights issues and collective land title, including in relationship to ILO Convention 169. And he has spent over 10 years working on the land rights program and has managed to assist more than 95 indigenous communities to be legally recognized by the government of Cambodia. So again, a very important intersection as we think about the issues both for workers and for social movements coming together to shift the power balance. Mr. Sophorn, I pass the floor to you.
Thank you, JJ, and good evening from Phnom Penh, Cambodia. It's almost 11 p.m. here. It is very interesting having joining this as a webinar and worldwide. I am very happy to be in the group and sharing my point of view, my experience with regard to the topic about joint employer liability in garment sectors, textile in Cambodia. As you know, Cambodia is a developing country, just have a democratic government after the United Nations Transitional Authority in Cambodia in 1993, which formed the democratic government to be ruled by the people, for the people, from the people, and so on. So with this framework, Cambodia has attracted many investors, in particular through the GSP of the United States and EBA policy of the Europe, which is very attractive for not only the simple investor, but brand who come to Cambodia for investment. So with this context, the labor law of Cambodia was passed in 1997 concerning the general employment contract with some exception that is not covered by the labor law. So this labor law has contributed a lot to economic growth, development, and human rights protections. However, there are challenges. Let me do presentation the challenges at the end of my Note, the labor law provides legal basis for employment relationships between employer and employee, while the employer and the brand relationships does not disclose. So, however, in practice, the relationships between employer and brands is established legally by separate law. And more or less, it has connection to legal jurisdiction of Cambodia in this context. During the COVID-19 pandemic, in 2020 and 21, the garment and textile workers has lost significantly their income without appropriate legal remedies. Most of them have suffered from both COVID-19 pandemic, wage loss, and livelihood because of the measures and also the closure of the factory and so on. In one hand, the closures of factory, and another hand, they lost job, lost wage, while their income has nowhere. And the lost part has gone somewhere without explanations or without legal process at all. Who should be held accountable to these issues, especially the loss of income and wage for the workers? And what action that the affected workers can take for remedy legally in Cambodia? With regard to question number one, there has to be someone to hold responsible, to be held responsible for wage loss of employee. Legally, if the contractual relationships between employer and employee remains valid, so the violator or the breach party shall be held responsible. The breach of contract is one of the legal reasons for claiming damage and compensations according to labor law of Cambodia, and also the law on minimum wage. Generally, the collective action is legally open to take according to law of Cambodia. There has to be a written decisions, in my view, on why the current employment contract between the employer and employees is not performed during the COVID-19 pandemic in some factories, and make the employee lose their wage or their income. Was it the force majeure or the act of God? In this context, the employer may say, no, it is the branch responsibility that they cancel order, purchase order. Then the factory has to be closed. In this legal process, the affected party, according to Cambodia law, enjoys rights to take legal actions. For example, employer says the wage loss was because of COVID pandemic and the government actions. There was no purchase order from branch. So, and the questions, who knows if the reasoning is true or not? Then these actions cannot be disclosed to make it transparent or to explain the employee or the lost workers, the lost wage worker. In business transaction, the brand have established legal relationships with employer who bears legally binding employment contract with the employees.
Mr. Sophorn, we have about 1 minute left.
Okay, the branch may have some kind of responsibility and liability to the loss of wage and have caused the affected employees' rights and interests. So there is enough law and procedure in Cambodia to enable the affected employee to take legal actions, to claim damage and compensations, and to make brands also get involved through the legal actions. However, there is no labor court in Cambodia, only general court. And the relationships between employer and the branch is not transparent or it's not disclosed normally. So thank you. If there is any questions and clarifications, I'm pleased to do so. Thank you.
Thank you so much. And thank you to all of our panelists. I think we would have liked to hear from each of you for the whole hour alone. So my challenge back to our Asia Florwage colleagues is that I hope we will have many more opportunities to think together, to pull from our history the legal concepts that have held true since the beginning, which is the entity that has the resources and the power to make sure wages are paid should also have the responsibility. And that is the case whether it's across national borders, whatever kind of corporate structure supply chains want to build. This is fundamental, and that it will take very strong unions and organizations to both advocate for this in the way that trade unions operate, as well as work with lawyers like the lawyers that we have here to litigate these cases. And when we do that, we can bring the law up to date. We know that there are moments in history where the law meets the moment. And I think together with everyone on this call is an example of how we start imagining how that happens. Before I pass back to Ananya, I also wanted to recognize we have esteemed and elder colleagues, including myself, who have been honored to make remarks on this work, but it has really been led by a new generation of movement labor lawyers and organizers with the Asia Floor Wage. We've gotten to hear from Swasthika and Gerry today. We also have their colleagues, Abida, Ravi Kumar, and especially Nivedita, who has coordinated this process globally. And so I think it's also just a good reminder for all of us that we have a lot to bring, but also it is the next generation of unionists and labor lawyers that are pushing us forward. So for that, we appreciate all of you. And I will return the floor to Ananya.
Thank you, JJ. As you say, there has been a significant teamwork behind all this. Before we close, I just wanted to see, Ashim, would you like to make some remarks since you did the presentation and now you've heard a lot of people? Do you want to make a couple of points?
Well, I think it has been a very, we just tried to pose the problem, and I think the experience of all our team members as we try to deal with this issue, there is difficulty. Just as Rasheed has already mentioned, the problem that can happen in the Asian countries, and we are aware of it. And I think, as JJ has said, this is just the beginning. We need to have a far more conversation, and many of these legal questions require much more deeper depth of analysis that we need to go. But I do want to just end up, or at least make two quick things, that what is important is, like it was clear from everyone's viewpoint, that we have to change the narrative of this buyer's notion, that the brands are actually buyers of the garments and not actually producers of the garment in the developing countries. And I think the more we can change that narrative, the more easier it will be to really bring out the idea of a joint employer. And I think that brings up the combination of both the larger campaign and the legal work, which can only come through litigation. Now, the second thing I think it's a great, with both Jeff and Krishnendu really bringing out and including Karamat, that there is a moment in history where actually global supply chain is being like it's a pincer movement, something coming from the duty killings framework, which is actually forcing accountability. And I think we need to have a similar movement which brings the joint liability from the bottom. And I think our interest is to get into that direction. How long it will take, as I said, all litigation is walking the path. If we don't do the litigation, it's a theoretical question. If we do the litigation, either we win or we lose. So I think the Asia Floor Wage has chosen the path of litigation, and I hope all of you will be there to really help us in shaping this discourse, and as well as we move the legal struggle forward. So with these words, Ananya, you can, I'm finished. I just wanted to make this 2 points.
Yes. So today was, we have been working on analyzing national laws, which resulted in the brief. We have also filed complaints in some of the countries and are exploring filing further complaints in those countries, as well as new complaints in some of the newer countries which haven't done it yet. So this is just the beginning of a journey. And we also know, all of us who are in the movement, that litigation is or has to be accompanied by movement building. This is not something that just happens in the courts. It is also something we have to win in the language, in the discourse. So we really have to stop calling brands buyers. We all do that. We have done it. We would like to suggest that we stop calling them buyers, and really we can find different terms. They are basically contracting out production of their branded goods. I would like to give a huge thanks to the speakers who have come today from all over the world to take part in this for the first time. And also recognize the Asia Floor Wage Alliance team and our allies and our trade union members and labor organizations who have been working with us on this for, I would say, more than a year now. And also, I want to thank the tech team today. We have an invisible team of both our staff and volunteers who are handling the technical part of this webinar, which is quite challenging with 9 simultaneous languages. And a huge, huge thanks to the interpreters of all the 9 languages. It's a tremendous job with all this technical language. It takes a lot of commitment to translate these matters, even if it is your mother tongue. So thanks a lot to the interpreters, and thank you everybody. We are ending on time, which is amazing. We were half an hour late last week. So thanks to everybody for keeping to the time on this very complex topic. So good day, good afternoon, good night. And for all those who have stayed up late in Southeast Asia, I hope you go to bed soon. And thanks a lot.
Thank you. Thank you.
Bye-bye.
See you.
Thanks, everyone. Bye.
Thank you.
Bye.
Thank you.
Bye,
All,
everyone.
all.
Thank you.
Bye-bye.
Bạn ơi,បងជួយអង្គុនច្រើនបង តាមជុំនេះតាមឆាតទេបង